I'd like to take a brief moment just to ask both of our panelists for their key takeaways or their final thoughts. Matt, you led us off this afternoon. Perhaps you want to be the first one to close us out with a few key takeaways.
Sure. I'll just kind of go on two that I've already talked about, but they can't be said enough. Seriously, review your HR and third-party agreements. If you are in-house, there's no better way to earn respect and appreciation from the C-suite than if you're able to identify and potentially resolve this issue prior to it ever becoming to a government investigation. And point two, which is related to that point, is if you find that you have no-poach agreements, I think at that point, I think you can do that, make that determination on your own. But if you've identified them and find that you have them, I think that's a time where you really do want to engage outside counsel and discuss those no-poach or non-solicitation agreements or no-hire agreements. Even if you think that they're okay, you know, DOJ, as somebody pointed out in the comments, has said more recently they're looking for someone to set an example, and your company's probably not the example you want DOJ to set. So I would just, you know, submit to you that it's better to get a second opinion or to talk to outside counsel and discuss the no-poach agreements you have in place to give yourself added comfort or to make any changes that may protect you in the future.
Thank you so much, Matt. Kenina, you were our second speaker. Perhaps you want to close us out with a few of your final thoughts as well.
Sure, and I think my point is really to enforce what Matt is saying in terms of the importance of evaluating the agreements that you have, and you know, when necessary, engaging with outside counsel to discern, you know, what the antitrust risk is in the non-competes you have and whether or not they would be viewed as naked no-poach agreements or potentially ancillary to a legitimate business justification. And I think just my big takeaway from my portion of the presentation is that the standard is still up in the air. While no-poach cases, you see more and more of them crop up throughout the country, the standard review debate is still out there. You have some courts saying this is definitely rule of reason and others saying, no, this could be per se. And that uncertainty alone, plus the fact that the courts are generally allowing these cases to move past the motion to dismiss stage and get through lengthy and, you know, the most time-consuming and costly stage of the case of discovery is just another reason why it is so important to take a look at the agreements you have and be able to identify whether you have any that pose antitrust risk and what steps you can take to reduce that risk.